And as a result, we might not spend much time on this, except just to clear one thing. On paragraph 10 of your affidavit, you're saying the conversion of the data does not involve the manipulation of the data. The conversion. What does conversion involve or entail?
I will explain in details what this sentence means.
Yes.
It means as I'm converting data, the original data remains the same.
Yes.
Cooked.
It's
not cooked, in other words.
Not cooked. Yes. Because my understanding, I'm going to tell you, my honest understanding of this. When you convert something, it means you are interfering with its state of originality. Is that not so? In other words, you're changing it here and there in order to suit what you want it to be in terms of your own specifications. Is that not so? That's conversion.
Okay, yeah. That's true, but in this regard, we convert, but the original remains the same, and unconverted, it's locked, there's no way you can change it.
My own understanding.
Yes, ma'am.
When you say you convert the data, you convert it from a certain medium and you place it in another medium.
By converting, I'm using X or Y.
That's it, yeah?
Yes. To convert it into a PDF as it is, the originality as a PDF, like they're saying.
Fine, yeah. I'm saying, yeah, you move it from one state of matter to another state of matter.
Yes, and then also
common sense, science number one.
To an Excel format.
Yeah.
That you see on my affidavit as an HRA.
Right.
But after doing all this, the original data remains the same.
Okay, fine.
Hi everyone, welcome back to my YouTube channel. My name is Zimasa, for all those who do not know me. If you are a returning subscriber, thank you so much for joining us on yet another video. If it is your first time here, you're very much welcome on this platform. Please do kululu your bike and feel at home. Now, if it is not your first time, thank you so much for joining us on yet another video. I think I'm saying that for the second time. But anyway, if you have not subscribed, I do kindly ask that you click that subscribe button, like, comment, and share this video. By doing so, you do help this channel to grow in numbers. Also guys, if you like this video, then you do help it to reach more people, you know. So please do not forget to like this video. Make sure you like this video. And to everyone who has been watching the ads, thank you so much from the bottom of my heart. I ask everyone else to watch the ads. I know they can be boring, but then they do help me to grow financially, you know, on this platform. Thank you so much to everyone who's been supporting this channel from day one. So previously I did a poll, or I asked a question on the community side of YouTube if I should be doing the Senzo Meyiwa case, and you know, people came up and said, Zim, we want you to do this case. So this is me. This is my first video on the Senzo Meyiwa case. And you know, I am actually watching court. And I just have a question. What is it that is happening in that court? The judge seems to be for the, you know, for the state. The way he's leading witnesses in court, I feel like it is actually uncalled for. So what I'm going to do, I will put those clips, just watch them until the end. I don't understand even the way he's actually treating people, like the way he's actually treating those lawyers in court. It's like, I don't know whether he's trying to challenge them to be on their toes, to be confident, or is he really for the state? Watch these clips and tell me what you think. This was Advocate Mnisi questioning, you know, the witness on the evidence that he actually brought in court. Now, Judge Ratha keeps leading, you know, Sergeant Mabaso, who's also, I think he's also a cell phone expert. So he's actually what they're doing now in court, they are going through the cell phones to see whose number is this, who is it that was contacted. But here, Judge Ratha, the way he is leading witnesses and the way he keeps, you know, arguing with the defense team, something is off. You know, there was a point where he even said common sense. when did we start using common sense in court? Or maybe I don't know, I need to go back and study. But do we use common sense in court, or we use evidence? Or maybe in that situation we had to use common sense. The question that I actually have is he biased? I don't know whether this is the right term to use. Is he biased, or he just wants the defense team to be tough and confident lawyers? You know, there are those parents that actually tough love. Is he giving them tough love, or is he biased, or is he for the state? How can you lead witnesses the way, like as a judge?
Thank you. Let's proceed.
These issues were canvassed with the witness the first time around. Is he now being cross-examined on the same issues, and the witness have noticed caught off guard as he only came here to testify about financial.
Thank you, Mnisi. I hear the concern of my colleague, Madam. I think I'll be very cautious in my approach if my colleague then says I am trying to be unfair to the witness, but I'll be very cautious. No, he hasn't said that. No, he didn't say I'm very fair. I'm being unfair.
Mr. Mnisi, wait, I'm asking you, is that what you're saying?
Yeah, we were just saying that the witness is being very cross-examined and on issues that is already testified on.
Yes, undergo your cross-examination. Last time.
He did.
Now we are re-cross-examining him again.
May I contextualize that?
Yes.
Thank you. It should be remembered, my lord, after it's to be brought together so that each piece of that evidence fits in a puzzle in order to form.
Which procedure is that?
I'm a bit Shakespearean, my lord, but let me come down to the level of generality. Yes. What I'm trying to say, my lord, is after this witness has testified,
yes,
this court went on to further hear a lot of other information.
Yes.
The basis of which is we need to specifically, as litigants, us and the state, we need to fit that information in the proper space in the puzzle so that we form a holistic picture. I am not basically trying to be unfair to this witness here. I'm trying to get a certain picture.
No. To be fair to this witness,
yes, madam.
Let him read the evidence which he adduced. How many years? How many months ago? Yeah.
I think that
No, that's the only fair way. Hello?
8 or
6 months ago.
6 to 8 months.
That's it. Let him revisit that evidence. Then you can re-cross-examine him. To be fair to him.
Yes, madam.
Yeah,
Yes,
please.
yes.
If you want to do that, do that. But I know of no procedure, which, as you say, because you've involved in a myriad of other issues after this witness has testified, you want to put the subsequent myriad of information which you have heard and which this witness never had the opportunity to hear into a proper perspective. That's what you're saying. And you want to fit it.
No, madam.
That's what you said.
This witness, madam, with due respect, does not have to hear the information that was proffered before court subsequent to his testimony. He is only here to give his portion of the testimony. It is my duty as a litigant and the state's duty as a litigant on behalf of the state to take that information and fit in those little puzzles in order to form a holistic picture, madam.
Yeah, okay,
it is not for him to do that. May I request the opportunity to proceed? Because I'm just about to wrap up.
This court, in view of fairness,
yes,
this witness must be accorded an opportunity to go over his evidence, and then you can re-cross-examine him. 8 months ago, that's what he says. That's why he says, I can't remember. Okay, to be fair.
Yes, ma'am.
That's it. I don't say you can't cross-examine him. I say to be fair, let him revisit his evidence and the cross-examination he underwent. Then you're on equal footing.
No, it's fine, madam.
Yes.
I don't have a problem with it.
Yes.
Thank you, madam.
Yeah. What section is it, by the way? 160, just read 160, is it 167 or 6? 166 or 7? Let's read it.
May I quickly
Let's read it. Okay. Here's the Bible. section? Oh, look what this book is.
166. Cross-examination and re-examination.
Yeah, what do you say? Let's read.
It says, subsection 1.
Yeah.
An accused may cross-examine any witness called on behalf of the prosecution at criminal proceedings, or any co-accused who testifies at criminal proceedings, or any witness called on behalf of such co-accused at criminal proceedings, and the prosecutor may cross-examine any witness, including an accused called on behalf of the defense at criminal proceedings. And a witness called at such proceedings on behalf of the prosecution may be cross-examined by the prosecutor on any matter raised during, may be re-examined by the prosecutor on any matter raised during the cross-examination of that witness. And a witness called on behalf of the defense at such proceedings may likewise be re-examined by the accused. In subsection 2, the prosecutor and accused may, with leave of the court, examine or cross-examine any witness called by the court at criminal proceedings. Then subsection 3A, if it appears to a court that any cross-examination contemplated in this section is being protracted unreasonably and thereby causing the proceedings to be delayed unreasonably, the court may request the cross-examiner to disclose the relevancy of any particular line of examination and may impose reasonable limits on the examination regarding the length thereof or regarding any particular line of examination. And subsection B, the court may order that any submission regarding the relevancy of the cross-examination be heard in the absence of a witness.
Yeah, so I'm being fair when I say this witness, after 8 months, having given evidence, and I don't even have to ask him how many times subsequent thereto he has appeared in court giving evidence. It's only fair that he must refresh his mind, and then you can re-cross-examine him, because that is re-cross-examination. Okay. It's not examination in chief by the state. It's not cross-examination in chief by the state. Neither is it cross-examination by you, Mr. Mnisi. What you are doing to this witness, you are re-cross-examining him on issues which you have traversed. And now you are saying you want to fill in some pockets. No problem. Let him refresh his memory, and we can revisit the re-cross-examination. Okay.
With due respect, I think there's a point where me and the court do not have sufficient consensus, where we do not understand each other. Maybe it's the way in which I'm expressing myself, maybe it's the way in which the court interprets what I'm saying. But I am not saying that through this testimony, through my asking of this witness questions, my cross-examinations, I want to fill in certain things. No, that's not what I'm saying.
Okay, fine. But you've heard me there. That's my ruling.
Thank you, Manat.
Yes, sir. You can arrange that date. Okay, no problem.
As a court, please, can we then adjourn at this stage until Monday?
Okay.
For the resumption of the cross-examination of Lieutenant Colonel Coase.
Okay.
But just tell me what you think with regards to this, and I will see you on my next video. Please do not forget to like this video. Thank you so much for watching until the end.